We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 31st, 2025, the officer observed the defendant's vehicle run a red signal light at the 3400 block of Live Oak Street in Harris County, Texas. The officer further observed the vehicle completely failed to stop at a red signal light and activated his emergency equipment and conducted.
All right, quick pause. Did you catch what just happened? Mr. Davis is now facing 2 separate charges, and each one carries the possibility of up to a year in jail and a $4,000 fine. But the real twist here is that he allegedly gave a fake name while already being a fugitive, which pushes the situation into Class A misdemeanor territory. At that point, what started as a simple stop isn't simple anymore. It's a case that's snowballing fast with bigger legal consequences.
To the traffic stop. The officer made contact with the defendant, who was observed to be behind the driver's seat of the vehicle, and the defendant stated that he does not have his identification card with him, and the defendant gave a fictitious name of Fisher Leroy with date of birth January 1st, 2006. The officer ran the name through NCIC and found a DPS picture that does not remotely resemble the defendant. The defendant was asked if he was given the correct information, and the officer walked back to his patrol vehicle to double check, and the officer then observed the defendant exit the vehicle.
And here's where the story gets even wilder. After giving a fake name, he didn't just stay put. He ran from the scene and jumped into another car to get away. That's a bold move, and it instantly turns the situation into a much bigger problem for law enforcement. In moments like that, officers have to make a split-second decision. Do you pursue immediately, or do you slow things down and call for backup first? What would you do in that situation?
Sprint away despite giving him orders to stop. The officer ran after the defendant and observed the defendant get into another vehicle, the passenger side. The other vehicle drove away, and the officer gave the last direction of travel over the radio, but was not able to locate the vehicle. The officer walked back to the defendant's vehicle, secured it, and conducted an inventory check, finding a debit card inside with the name Kendrick Davis. The officer ran the name through NCIC and found a hit with a date of birth of 2/10/2003 with multiple Class C warrants, and ran a driver's license check with the defendant's picture and with date of birth. The DPS picture matched the defendant, and he was able to positively ID. And that's it, Your Honor.
Now let's talk about bond, because this is where judges start weighing some serious factors. 2 of the biggest things they consider are danger to the public and risk of flight. In Davis's case, the judge isn't focused on small details like his birthday coming up in a few days. What really has the court's attention is his record and the pattern of behavior surrounding this case.
I'm going to find that there's probable cause to go forward on both of your cases. The reason I'm bringing you out now is because there's no bond that's set on your cases, and we have to set you a bond. One of the things that I use to determine on what to set a bond is how dangerous you are, because I've never met you before. I don't know you, and all I know is that you've got a birthday in 5 days. So he's on bond for an aggravated robbery now, right?
Yes, Judge. It's my understanding, I think it was a 2B, it looks like. I don't believe bond conditions and everything were put in place until a few days ago.
Okay. So the charging instrument was filed November 13th of 2024. I think that you may well be right. In that case, it says here, a Kendrick Richard Davis hereinafter saw the defendant heretofore on or about August 12th, 2024, did then and there unlawful.
Then the details of the alleged robbery come out, and they're disturbing. This isn't just a simple theft accusation. The report describes pistol whipping, stomping, and multiple facial injuries to the victim. When violence reaches that level, it explains why the judge becomes laser-focused on public safety. At that point, every decision in court revolves around one question. How do you prevent something like this from happening again?
Fully while in the course of committing a theft of property owned by yada, 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 with intent to obtain and maintain control, intentionally and knowingly cause bodily injury to the complaining witness by using and exhibiting a deadly weapon, namely a firearm. Complainant McSweeney advised that defendant Davis proceeded to pull a pistol from his waistband and pistol whip him with it multiple times on his head and face area, causing multiple cuts and bruises to his head and face area. As he proceeded to fall down on the ground, he continued to strike him in the head and face area with a closed fist and then stomp on his face with his foot. Complainant McSweety stated that he was in fear for his life and felt severe head pain as a result of the assault. I see that he has also picked up an evading arrest in a motor vehicle
Yes,
the
sir.
day after our two cases. How? Oh, I guess that's how they caught up to him, right?
That's how
They
they
must
caught up
have.
to him and they found him, and that's when they arrested him on that, and then he got picked up on leave, I believe.
Okay, so what happened in that case? Is he like driving 100 miles an hour? Is he just?
Yes, Judge.
That's when the judge lays down strict conditions. No driving, no weapons, and absolutely no excuses. And the warning couldn't be clearer. At one point, the judge even says it doesn't matter if there's a burning building full of kittens. The rules still apply. It's a dramatic way of making one point very clear. Break these conditions once, and the consequences will get much worse.
It says that the officer observed the defendant conduct an improper turn and failed to turn into the correct designated lane. They activated their lights and sirens, and the defendant evaded at speeds of 90 to 115 miles per hour for 3.5 miles on the highways and multiple residential and business streets.
Okay. I think that you are an extreme danger to our public, and I'm going to do everything in my power to protect our public. The first thing I'm going to do is I'm going to order you not to drive. You will be signing an affidavit with me today promising me you're not going to drive. I don't give a rat's behind what is going on in your life. I don't care if there's a burning building. You have to say 50 kittens. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months jail and a $500 fine every time you get into a car and drive. Do you understand?
Yes, sir.
I'm also putting in this affidavit that you're not supposed to be in possession of any weapons as well. If I find that you have a weapon, because I don't know if you're going to get out or not, and because these cases, because of the nature of the aggravated robbery, because of the nature of this one, I'm making his bonds high, I'm going to set them at 20,000 each.
So can I make an argument?
Yes,
Okay.
absolutely.
you, Judge.
I don't want to get ahead of myself, please. Yes.
So I was appointed to Mr. Davis this morning. I was able to talk to him a little bit in the holdover.
Finally, the court lands on the decision. $20,000 bonds, house arrest, and GPS monitoring. This isn't just about punishment. It's about control and supervision while the case moves forward. The judge is trying to balance accountability with public safety. But here's the question everyone watching might be asking. Did the judge go too far with these conditions? Or is this exactly the kind of action needed to protect the community?
We are requesting PR bonds for both of the cases. He's 22 years old. 21 years old. He's lived in Houston his whole life. He has a lot of family in Houston. His grandparents, mom, daughter, and siblings. Prior to being in custody, he was working at Builders First Source for around a month. Mr. Davis also lives with his grandfather who has cancer. Mr. Davis is his caretaker, is my understanding. Mr. Davis has no savings and was found to be indigent by the court, so we are requesting a PR bond.
I think that he is just a complete danger to our public. I can't possibly give him a PR bond due to the nature of both of the charges that you are facing now. I think that you're a flight risk. You've done everything in your power to evade capture. You've produced false names. So I find by clear and convincing evidence that you're an extreme flight risk. You're a danger to our community. And I'm going to set your bonds each at $20,000. I don't know if you're going to be able to post bonds, but if you do, I'm going to order you under house arrest if you do get out. And I'm going to order you to obtain a GPS monitor on your ankle. Like I said, you will be signing an affidavit with me today promising me you're not to be in possession of any weapons and not to drive any vehicle whatsoever for any reason. If you do, I can have a contempt hearing. Do you understand?
Yes, sir.
The felonies are set for April 7th. I don't like to set them out too far just in case. If you want to, we can do up to 30 days. It's up to you.
That's perfect.
And then we'll come back. I don't know. We'll see what circumstances have changed, and then we'll go from there and just keep us in the loop.
Okay, thank you.
All right. I need you to sign this for me. I need him to sign bond finished with Felicia, and then after that, he's pretty done.